All right, welcome everyone. If y'all would come in and take your seats. My name's Mark Lemley, and we're delighted to have you here. There's been a tremendous amount of change and movement in the PTO and administrative revocation systems in the last few years since the AIA was passed. And we've got a really all-star cast who's here to talk about the PTO proceedings, about how courts interact with the PTO proceedings, perspectives from the district court, from the Court of Appeals, from the PTO, and practicing lawyers and academics. So I'm going to start off by welcoming our conference co-chair and co-sponsor, Ken Correa of Samsung. Ken is the Senior Vice President at Samsung Electronics, and he's the head of the U.S. IP Center based here in Silicon Valley. And Ken and Samsung have been extremely gracious in helping us put this together, and we're delighted to have him here. So, Ken.
Good morning, everyone. Well, my name is Ken Correa. You guys know that already. And we are very proud to have sponsored this Stanford Law School Patent Law Conference for the last 6 years. And, on behalf of Samsung and Stanford Law School, I'd like to welcome all of you to this conference. Now, I think back in 1990, I was working as a patent litigator representing mostly defendants. In one of those cases, I was trying to invalidate the patent in suit and found very promising prior art reference. So I wanted to utilize the post-grant review proceeding available back then, ex parte re-examination. When the senior partners at my firm got the wind of it, they put a stop to it, saying that, Ken, you'll be essentially committing a malpractice if you recommend that to your client. I said, why? Well, as soon as you file the petition, it will be assigned to the original patent examiner. He or she probably thought that he or she made a right decision in the first place. Besides, don't forget it's ex parte, so you don't get to participate. Patent owner does. So between the original patent examiner and the patentee, good luck. Your prior reference will be dead, and you won't be able to use to invalidate the patent in the litigation because of estoppel. With sentiments like that, back in 1990s and most of 2000, you rarely ever saw defendant utilizing post-grant review to invalidate the patent. Fast forward to 2015, after the passage of America Invents Act. Defendants in patent litigation, they routinely utilize post-grant review proceedings, such as inter-parties reviews or the covered business method reviews. So I think the practice of utilizing post-grant review by the defendant is so prevalent that I would dare say that nowadays it would be a malpractice for defense counsel to at least discuss the use of post-grant review with their clients as part of defense strategies. And with this amount of growth, obviously there is a growing pain. Already, I think there are 2 bills introduced in Congress to change the post-grant review proceedings. Obviously, many patent owners do not like post-grant review proceedings. And also, defendants are not necessarily all enamored with the post-grant proceedings either. I hear from my friends on the defense side that they're concerned that it is getting more difficult to get IPRs or CMBRs instituted by the PTAB, Patent Trial and Appeals Board. And PTAB itself is going through growing pain. Even though they are hiring judges as fast as they could, it is still inundated with a growing number of petitions for IPRs and CMBRs. So to explain all this, to discuss this state of affairs, where it is heading, and more importantly, what it all means to you We have assembled a panel of distinguished judges, professors, and practitioners today, and we are particularly honored to have Judge Kimberly Moore from the Federal Circuit, Judge Graywall from the Northern District of California, Judge Scott Bolick from PTAB, and my good friend, Judge Peter Chen, also from PTAB. So let's give speakers a warm welcome.